It is clear from the evidence that the defendant had an overarching plan to kidnap the child, which was executed on both occasions. Her acts were not spontaneous, and it was an organized plan. Specifically with the July 2018 pickup order, the defendant violated the court orders when the Clark County judge issued the orders. The defendant essentially admitted to concealing the child for 33 days at the time of the hearing when she failed to rebut the arguments made at the hearing.
All right, so this is case 338469, State versus Julie Hammer. My understanding is today is our time we're doing a Petrocelli hearing regarding the state's motion to admit evidence of prior uncharged conduct of the defendant. Right?
That's correct, Your Honor.
That's a correct statement, Your Honor.
You guys want to state your appearances for the record?
Yes, Alissa Engler and Chelsea Kallas for the Attorney General's Office on behalf of the state.
Michael Castillo, 11531, and my colleague Sophie Salcedo,
15316, Your Honor.
on behalf of the defendant Julie Hammer, present at liberty.
Good morning.
Good morning.
All right, it's the state's motion.
So I have two witnesses. None are on blue jeans, so just throwing that out there.
You got live witnesses?
They are live.
Wow,
Yes.
that's awesome.
Which the defense appreciates.
It's nice to be able to get back to what we used to do, right?
No, with the masks.
I don't even remember it, to be honest.
All right, you want to call your first witness?
And just procedurally, Your Honor, I'll seek guidance from the court on this. Both myself and Ms. Salcedo have both been fully vaccinated. I tend to sound a little bit muffled under the mask, so during my questioning only, I may drop the mask down slightly unless the court has an issue with that.
Supposed to keep the masks on at all times in the courthouse.
I'll leave it on at all times then. All right. And the defense would invoke the exclusionary rule at this time.
So the state's first witness is Attorney John Jones.
Better come all the way up on the witness stand. Once you get there, if you please remain standing, raise your right hand and be sworn.
Do you solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth so help you God?
I do.
Please state and spell your name for the record.
John D. Jones, Jones, first name John.
Mr. Jones, go ahead, counsel.
Thank you, Honor. I'm going to come up here so I can not shout as loud, I suppose. Good morning, Mr. Jones. How are you employed?
I'm an attorney, licensed practice in the state of Nevada.
And where do you work?
My own firm, Jones & Lobello.
And how long have you worked at Jones & Lobello?
We just started roughly a little bit under a year ago. Prior to that, I was a partner at Black & Lobello.
Okay. And what is your educational background?
I received my BA from Dickinson College in Carlisle, Pennsylvania, and my JD in 1993 from the University of Pittsburgh.
And are you a licensed attorney in the state of Nevada?
I am.
And how long have you been a licensed attorney in Nevada?
Since 1998.
Are there any other states that you've been admitted to practice law in?
I'm admitted to practice in Pennsylvania. I'm on, I guess you would just call it retired status as far as they're concerned.
Okay. And when did you first receive your admission in Pennsylvania?
1994.
What areas of law do you currently practice?
I practice nearly exclusively in family law, child custody, divorce, prenuptial agreements, anything of that nature.
And has that primarily been your law experience through your career?
Correct.
Family law can be generally a broad area. What do you primarily focus your practice on?
Usually very high-end litigation, high net worth divorces, high conflict child custody cases, trials primarily.
Okay. Do you have a client by the name of Mary Rasmussen?
I do.
Does Mary have a nickname that she goes by?
She's always been referred as Murphy.
Okay. And how long have you represented Murphy?
Well, I think I first got on the case in 2012 or 13, so it's been roughly 8 to 9 years.
And in what capacity do you represent Murphy?
I'm appointed by the legal aid of Southern Nevada as a pro bono attorney.
Okay. And what type of case do you represent Miss Murphy?
I represented her and have continued to represent her in a child custody case with the defendant.
Okay. And when did you make your first appearance on behalf of Murphy in the domestic case?
I couldn't tell you exactly, but it was either, I think it was early 2013 or late 2012.
Okay. And you mentioned the defendant. How do you know the defendant?
Simply from having several hearings a year for the last 9 years on the child custody case.
And what is the defendant's name?
Julie Hammer,
And can you just point to her and identify an article?
she's sitting on the far end of defendant's counsel table.
And what article of clothing is she wearing?
She's wearing a long mask and a black and white sweater.
Your Honor, will the record reflect the identification of the defendant?
Record will so reflect.
Is the defendant an opposing party in that litigation that you represent Murphy on?
She is.
Is there any other opposing parties in that case?
There is a gentleman by the name of Gonzalo Galindo who was also brought into the case right around the time I got on the case back in 2012 or 2013, who is also a defendant in the action.
Okay, and who is Gonzalo Galindo?
He is the DNA father of the minor child in question.
Okay. At the time you made your first appearance in the domestic case, what was the status of the case?
It was gearing up for an evidentiary hearing for final custody orders.
Okay. So at the time that you entered the case, were there only temporary orders in place?
Correct. That is correct.
Okay. At the time you entered the case, had parentage been established?
It had a prior order from Judge Nathan at the time. There have been several family court judges on this case. Had concluded the right of Murphy as to be considered a parent.
Okay. Just generally speaking, what is parentage?
Well, in many cases, it's whatever family court judge says it is. Some people believe it's strictly DNA, but the law recognizes same-sex relationships where only one party carried or where they both adopted. Basically, parentage is the legal rights as established oftentimes by a court of law.
So at the time that you entered the case, what was Murphy's legal right to the child?
The parties had a timeshare order in place, and she was characterized as a parent to the minor child.
Was Julie Hammer, or the defendant, challenging parentage at the time of the evidentiary hearing that you were brought on to represent Murphy?
She had originally challenged parentage, and that was obviously declined by the court, that challenge. And at the time we were preparing for trial, parentage had been established, so hard to say whether she was challenging it when we settled the case and placed the settlement on the record. But in general, her attempt to involve Mr. Galindo in the case, I think, was an attempt to side-skirt the court's order regarding parentage.
Objection, cost of speculation.
So at the, you keep referring to trial, I keep referring to evidentiary hearing.
They're the same.
Are those
I
the-
apologize.
No, that's fine. So in domestic proceedings, are trials often referred to as evidentiary hearings?
Yes, particularly in child custody matters.
Okay,
I just call them trials because they're trials just like any other trial.
sure. When was that evidentiary hearing scheduled to occur?
I believe the final evidentiary hearing was set for October of 2013.
Okay. And did the parties ultimately go forward with the evidentiary hearing?
No, we had received a guardian ad litem report the prior week, and counsel for both the defendants and myself discussed potential resolutions for, I believe, the first 2 or 3 hours that we were set for trial. Obviously, in family court, the judges encourage those types of negotiations, and after lengthy negotiations, rather than go forward with trial, we ended up placing a stipulated settlement on the record.
What is a guardian ad litem?
In cases where there are concerns by the court that let's just say usually it's when there's high conflict cases, where there's concerns about either party possibly not looking out for the best interest of the child. The court has the authority to appoint a guardian ad litem whose job primarily is to make recommendations to the court as to what they believe is in the best interest of the child based upon their investigation, their conversations with the child, their conversations with the parties.
Okay. And that's a report then that you as the attorney are also able to review.
Correct. It's considered a confidential report, almost like a psychological custody evaluation report, maintained in the left side filing of the court, the confidential file of the front family court, and only lawyers are entitled to maintain a copy of them. They can't give them to their clients or just disseminate them to anyone else.
So instead of going forward with a trial, the parties came to a stipulated agreement.
That is correct.
Okay. And what were the stipulations of the parties in October 2013?
The parties, and I'll say all three parties, stipulated that they would share joint legal custody. And legal custody is decision-making authority, changing schools, doctors, religion, those types of day-to-day decisions that all parents are allowed to make either jointly or, if they don't agree, take it to the court to decide. And the parties agreed, actually, Ms. Hammer and Ms. Rasmussen agreed to joint physical custody on an equal timeshare basis, with Mr. Galindo's visitation time being derivative through Ms. Hammer's visitation time, meaning I believe it was Monday, Tuesday to Murphy, Wednesday, Thursday to Ms. Hammer, and then alternating weekends. And the Thursday that was Ms. Hammer's each week was when Mr. Galindo could have visitation. And there was also discussion about reunification between Mr. Galindo and the child because he had not been in her life for the 6.5 years before we reached the stipulation.
Okay. And were all the parties canvassed regarding the stipulation on the record?
Yes, I placed the settlement on the record. The court swore all of the parties and canvassed them after I placed it on. In fact, I placed it on the record. I believe counsel for Ms. Hammer had one addition that we agreed that I had just left out of the recitation of the settlement. And then the court, having already sworn the parties, canvassed each party if they understood and that they were in agreement to the final resolution, and all three parties said they were.
Okay. And then the court, did the court adopt the stipulations at the time of the hearing?
Yes, the court stated on the record that it was an enforceable settlement pursuant to EDCR 7.50, that I was to draft the order and submit it to counsel for signature. I did that. It was then submitted to the court with all three signatures of the three lawyers representing the three parties.
And I understand what EDCR is, but that's the 8th Judicial District Court local rules.
Correct.
And what does that rule specifically mean?
Basically, it says EDCR 7.50 states that a stipulation is enforceable if it's in writing, signed by both parties, or if it's placed on the record in open court.
Okay. And so until the time you could get a final order signed by all parties, the record that was placed, or the terms that were placed on the record, are enforceable.
That is correct.
Okay. In addition to the custodial determinations or stipulations, was there anything else of relevance in that stipulation?
Yes. Part of me being a trial lawyer, I was very much looking forward to possibly putting this trial on because I thought that the testimony of the guardian ad litem was going to be very damning, in my opinion, and favorable to my client. So one of the things I wanted to be sure of, absolutely positively sure of, if my client was not going to go forward with her request for primary custody, because that was what we were there for, was seeking primary custody of the child, was to ensure that the order was truly a final order. So we included language that was also stipulated to that the parties were waiving their rights to seek to modify the order, to set it aside under 60B, or to seek an appeal of the order.
Okay. And that was agreed by all parties.
That is correct.
And who drafted the stipulation?
I drafted the final order resolving parent-child issues.
Okay. And were all parties represented by counsel at the time of the stipulation?
They were, Ms. Hammer was represented by Louis Schneider, and Mr. Galindo was represented by an attorney named John Eccles, who has since passed.
And would the ultimate signing of the stipulation, did it become a permanent order at that point?
Became the final custody order controlling the parents' custody rights as it pertains to London.
And how did this order interpret Murphy's right as a parent?
She was absolutely positively identified and recognized as an equal parent to the defendant, Ms. Hammer, and also obviously to Mr. Galindo, even though her custodial rights were superior to Mr. Galindo's. As far as the recognition of parentage, all three parties were recognized as parents.
Did the order also establish Nevada as the home state of the child?
It did.
And what does the home state of the child mean?
Well, under the Uniform Child Custody Jurisdiction Enforcement Act, home state of the child is generally where the child has resided for the last consecutive 6 months. Obviously, in cases where people have moved around, sometimes it takes an evidentiary inquiry to determine what that is. And so that's where the situs of jurisdiction for any custody litigation would be with regard to this child.
And that determination is important for any future litigation that might come about.
It is.
And Nevada would ultimately remain the home state so long as a party remains in the jurisdiction.
Correct. If Nevada is the original decretal state, sort of old language they use in statutes, as long as one party continues to reside in Nevada, it would have ongoing exclusive jurisdiction subject to the court later possibly determining that it was an inconvenient forum, meaning both parents had moved away. It didn't make sense for this forum to be the situs of jurisdiction.
And ultimately, the stipulation that was issued, what was the court that came about in?
Clark County, 8th Judicial District Court, Family Division.
Directing you to September of 2017, so 4 years later, was the custodial timeshare modified?
It was. Based upon certain issues with regard to Ms. Hammer trying to change the school and other conflicts that were occurring in the case, in hopes that it would resolve those conflicts, the court altered the timeshare so that my client, Ms. Rasmussen, had the school week, Monday through Friday, and Ms. Hammer had Friday to Monday.
And so essentially the modification granted Ms. Rasmussen the school week and Ms. Hammer the weekends.
That is correct.
And was this the physical timeshare that was in place in July of 2018?
It was.
Okay. So directing you to July of 2018, did you become aware that London was missing?
Yes, I believe I became aware of it either at the end of June or the beginning of July, because I know when we went to court on July 31, my client hadn't seen the child for 33 consecutive days.
Okay. And so what did you do as a result of learning that London was missing?
Filed a motion seeking a pickup order. The police don't generally enforce family court orders that are simply custody orders, meaning it's not their job to force parents to give their children back and forth pursuant to the order. But a pickup order is somewhat different. It specifically directs law enforcement, both state and federal, to assist in obtaining the child for the party seeking it.
In your experience as an attorney who practices exclusively in family law, in general, when do courts issue pickup orders?
Generally, when a child has not been exchanged or has been withheld by one parent for a significant period of time, or when the child is believed to have been taken from the jurisdiction or taken far enough away from the jurisdiction that it's clearly intended to be a separation of the child from the other parent.
Okay. Was a hearing regarding your request for a pickup order, was there a hearing on that matter?
There was. It was scheduled for July 31st, 2018.
Was the defendant present at that hearing?
She was.
And who was the presiding judge at the time of the hearing?
Matthew Harder.
Did the court ultimately grant your request for a pickup order?
Yes, the court initially stated it would grant the pickup order. I had explained to the court that I believed it was already in chambers because I had submitted it with the anticipation that it would be issued. Towards the end of the hearing, however, the court made a specific order in addition to granting the pickup order that the defendant, Ms. Hammer, bring the child for the custody exchange to family court that day, I believe by 5 p.m.
And why did the court make that specific request to have the child brought to family court?
Because upon inquiry for the pickup order, I asked the court to inquire of the defendant the location of the minor child. Her statement was that she was with a family member. We then specifically asked, we need the address so that we can have the pickup order served. And the defendant told the court that she did not know the address that her child was located at.
During the hearing, what reasons did Ms. Hammer state for why she was not complying with the orders?
She stated that the child refused to go for the custody exchange the last 5 exchanges, I believe was her exact statement as to why she was violating the order.
Was that an acceptable reason to the court?
It was not, and it never is. Even when a child is 17 years old, the court will need to make an order before a parent gets to unilaterally withhold a child.
During the hearing, did Ms. Hammer make any allegations of abuse by Ms. Rasmussen towards London?
No, she did not.
During the hearing, did Ms. Hammer indicate she contacted Child Protective Services or law enforcement to report her reasonings for detaining London?
No, she did not.
So in other words, the only reason she gave for refusing to comply was the child didn't want to go?
That was the reason.
After the court granted the pickup order, and you answered that. Was the defendant during that court proceeding admonished of any consequences that would happen to her if she failed to comply with the order?
The court was very clear, and Judge Harder is particularly direct when it comes to the consequences of contempt, the consequences of disobeying the court's order. She was instructed very clearly that she would be incarcerated.
Okay. Would you have had to file additional paperwork if the defendant had not complied with the pickup order that day?
Yes, if she would not have brought the child to family court for the exchange that day, I would have had to have sought a bench warrant for her arrest, and that was also discussed at the time of the hearing.
And so Ms. Hammer was fully aware of all of the consequences that could happen for failure to comply with the court orders?
I don't know that I've seen a family court judge be quite so clear.
And to your knowledge, did Ms. Hammer comply with the court's orders on this particular incident?
She did.
Okay. And did you prepare the pickup order that was signed by the judge?
I did.
Okay. Your Honor, may I approach?
Yep.
And I'm showing you what's going to be marked as State's Proposed Exhibit 1. Do you recognize this order?
I do.
Okay. Is this the document that you prepared?
I did prepare this, yes.
And is your signature at the bottom of the page?
It is.
And does this appear to be a fair and accurate copy of the order that was signed by the judge?
It is a true and correct copy of the pickup order from July 31, 2018.
Your Honor, the State moves for the admission of Proposed Exhibit 1.
Objection?
And just for clarification, Your Honor, this is the one electronically filed on July 31st, 2018?
Yes.
All right. No objection for purposes of this hearing only.
So following the minor child's return, July 31st, 2018, to your knowledge, did she go missing again?
She did.
And when did she go missing?
I want to say September, October of later that year.
Okay, so just a few months later.
Correct.
Okay. And what did you do as a result of learning the child had gone missing?
I again filed a motion for this similar relief. It had unfortunately become sort of a chronic issue, and so I sought another pickup order.
And was your request for a pickup order granted?
It was.
Was Ms. Hammer present at that hearing?
She was not. We had served the order shortening time on her last known residence, the residence of record, on her roommate there, and she did not appear.
Most documents in family court, are they electronically filed?
They are.
At the time of the July pickup order in 2018 and the October pickup order, did Ms. Hammer have counsel?
There was no counsel present at the July 31 hearing for Ms. Hammer. She's had many lawyers at various times. I think she was representing herself from July 31st forward.
Are pro se litigants allowed to electronically file documents in the family court system?
Not only are they allowed to, they sometimes file a lot of them.
Okay. And to your knowledge, does Ms. Hammer have access to filing documents in the family court system?
She absolutely does. In fact, there are way too many people on the electronic service list, something I need to correct at some point. But yes, she has always been able to file documents on her own. I believe she's filed documents for other people as well.
Although Ms. Hammer wasn't present at the October 2018 hearing, do you have information that would support she was aware of the proceedings?
Yes. I'm trying to recall specifically. Well, first of all, we know that we served her partner, the person that she had been living with for, I want to say decades, for many, many years.
And that partner's not Mr. Galindo?
No.
Okay.
It's a same gender partner that she'd been living with for a long time.
Okay.
So we can only obviously assume that that person made her aware of it. I believe that in the process of trying to serve the pickup order, we learned that she was aware of what was going on. But
And
that's,
how did you learn she was aware of it?
I believe it was her mom, because we tried to serve the pickup order at her mom's residence in California. Right now, I'm drawing a blank as to specifically how I know she was aware of it.
Did Ms. Hammer file any responsive pleadings in the family court case after you had filed your request for a pickup order?
Yes, she did.
And what documents did she file?
I believe it was an opposition to the request, and I also believe she once again challenged the original order again.
And your request for a pickup order then was ultimately granted?
It was.
And to your knowledge, is that pickup order the order that is involved in this criminal proceeding?
It is. It was with the assistance of the Attorney General's office that we were able to get a little bit more traction with the authorities. And that was the order that was ultimately how she was picked up in Tennessee.
Okay. To your knowledge, were any of the allegations of abuse made, when did Julie first accuse Ms. Rasmussen of abuse towards the minor child?
It was after the pickup order had been served and the child had been returned. Ms. Hammer started to make allegations that she thought would ameliorate her violation of the order and her abduction.
And to your knowledge, were any of those allegations of abuse substantiated by CPS?
No, CPS had been involved several times based upon complaints, I believe, from Ms. Hammer and from other people at the behest of Ms. Hammer. Each time CPS investigated, the allegations were found to be unsubstantiated.
I'm going to object as to anything that CPS may have said.
I think he's speaking to his knowledge as to the substantiation, which would be relevant in the child custody proceedings because those come up ultimately in discussions at the hearings.
Still foundation and hearsay issues, Your Honor.
Allow for his present sense impression, but not for the truth of the matter.
To your knowledge, did Ms. Hammer file any actions in other Nevada counties related to the custody of the minor child in this case?
She has done so twice. Prior to the final adjudication, the stipulation we talked about initially, she found Mr. Galindo. She took a DNA test and filed an action in Nye County. Neither party lived in Nye County at the time, seeking to have a custody determination based upon a stipulation between her and Mr. Galindo that she hoped would then trump whatever the determination that Judge Nathan was going to make. Luckily, we got wind of it, and after Judge Lane had already signed the stipulation that she and Mr. Galindo submitted, we moved to set it aside, and he learned of the Clark County case that way predated the one that they attempted to file in Nye County, set aside the order, and the case proceeded in Clark County. That was the first time. Then after all of that, and after all of this, all that we've just discussed, they went and tried to file another action in Nye County related to the birth certificate, trying to basically get my client off the birth certificate, which she was on the birth certificate pursuant to the original birth certificate, but then the confirmation of it by the court, trying to have a new birth, get an order regarding a birth certificate that would eliminate my client and only include Mr. Galindo and Ms. Hammer. Judge Lane or his law clerk immediately recognized the name on the caption and issued I'll call it a scathing order. Let's just say a very clear order about the abuse of the civil justice process.
I'm going to object at this point. Calls for a legal conclusion, foundation, and hearsay as to anything Judge Lane may have said, or his law clerk.
I think the word scathing is the only thing that you can really object to. Everything else in there was factual. So,
And Your Honor, I'm going to get to the actual order, which I have here, and I have a certified copy of it. So just to kind of follow up on a couple of things, Ms. Rasmussen Murphy is on the child's birth certificate.
That is correct.
And that was since her birth.
Correct.
And that was signed by Ms. Hammer, the defendant, authorizing it at the time of the child's birth.
That's my understanding.
Okay. And so this second proceeding that was filed in Nye County, do you recall when that occurred?
I don't. I apologize.
That's okay. Do you recall if it was prior to the issuance of the July 31st, 2018 pickup order or after?
I believe it was after.
Okay. And were you ultimately served with a copy of that order?
The order, yes. I wasn't served, even though I represented the person on the birth certificate, I was never served with the attempted end around to Nye County regarding the birth certificate, but I did get a copy of the order.
Okay. And, Your Honor, may I approach? Showing you what's marked as State's Proposed Exhibit 2. Do you recognize this document once you review it?
I do.
And on the last page, there's a certificate of service. What is a certificate of service?
The service is where the court sent the order. And actually, the judge did a better job than I even recalled because he also sent it to the guardian ad litem at the time, which was Laura Dieter, Esquire. Served to me at my former firm, Black & Labello, and served the order to the defendant.
And Your Honor, as I stated, this is a certified copy of the order. And so its authentication is verified. So I'm going to be asking for move for the admission of Exhibit 2.
objection?
The one dated August 10th, 2018, counsel?
Yes.
Okay. No objection for purposes of this hearing only.
She admitted.
And when, looking at this document, when was this order filed?
August 10, 2018.
And when does this order state that the petition filed by Ms. Hammer was filed in Nye County?
August 1st, 2018, so a day after the pickup order was issued by Judge Harda.
Okay. And if you would, can you please read into the record, starting on the first page, line 25, and then keep going?
After review of the file and the history of petitioner's filings, the court has serious concerns about petitioner's abuse of the judicial system and their engagement in forum shopping. Would you like me to go further?
Yes, please.
Petitioners and the minor child have no ties to Nye County, and a very contentious child custody case, case number D12-469416-C, has been in front of the 8th Judicial District Court since September of 2012. That case has had a voluminous number of motions filed, argued, ordered, and appealed by the above petitioners. One of the appeals addressed by the Nevada Supreme Court involved issues regarding the child's birth certificate. Petitioners even had a hearing on July 31, 2018 before the 8th Judicial District Court, which was only 3 days before filing their petition to correct birth certificate. Petitioners have clearly known where to properly bring their petitions and motions, but they chose to actively avoid filing their matters in the court with the best understanding of the current situation. Petitioners are attempting to abuse the system by avoiding notice to all parties involved in the custody matter and the decisions made in the best interest of the minor child. Footnote. Petitioners are also doing this under the guise of template forms and implicit characterization of these matters as an agreed upon petition, which fails to account for the complex and muddled history of the custody matters before the 8th District Court.
And then keep reading until it is hereby ordered.
Currently, this is the third attempt by petitioner to manipulate the system and file matters relating to the minor child in another court, knowing that custody matters have been before the 8th Judicial District Court. Given the petitioner's behavior, this court finds it appropriate to give all relevant parties notice of this order so that they may seek appropriate sanctions or actions for sanctions or other remedies to deter this behavior from petitioners as such good cause appearing. It is hereby ordered that petitioner's petition to and amended petition to correct birth certificate are denied.
And if you would, there was a footnote about the best interest of the child. Are you able to read that into the record? As best you can.
Let's see. Multiple parties are involved in the custody matter, including a guardian ad litem appointed by the 8th Judicial District Court. Although the petitioners above characterize Murphy Jo Rasmussen as an incorrect, non-existent person, she is an important party involved in the custody matter before the 8th Judicial District Court.
Just to clarify, after the issuance of the July pickup order in Clark County, the defendant went to Nye County and filed these petitions.
Apparently immediately after.
And then after the issuing of this order, only a month or so later, the child went missing again.
That is correct.
And to your knowledge, how long was the child missing in that situation?
I want to say more than 100 days. I couldn't tell you accurately.
And to your knowledge, where was the child then found?
The child was found in Tennessee.
And at the time that the minor child went missing, in both of these instances, who had legal custody of the child?
Murphy Rasmussen, or Mary Jo Rasmussen, had been awarded sole legal custody.
So even though the parties initially had been awarded or stipulated to joint custody over the course of the case, that changed to sole legal custody to Murphy.
Correct.
Those were orders by the court.
They were orders by the 8th Judicial District Court, yes.
And legal custody, what does that mean in terms of traveling?
Well, generally legal custody means that you can't take you couldn't take a child out of school. You know, school decisions are joint decisions, or in this case, once my client was awarded sole legal, the only person who could decide about school, about medical care, about this type of travel, all of those decisions rested in the power of my client.
Court's indulgence. I have no further questions for this witness, thank you. Okay.
Okay. If I can just have a brief sidebar with opposing counsel, just on one quick procedural.
We will do our very best to be clear.
One of the issues that the court system has is
those who are present and have stated appearance
the defendants will be enjoined from using them any further.
All right, counsel, where are we at on this matter?
There was not a lot of detail about the attempted service.
If you go off on a rant again, I will act accordingly.
So this is a status check on discovery scheduling.
Morning, sir.
Good morning.
So you were first asked some questions about your qualifications. Are you, and if I'm using the wrong terminology, please correct me. Are you actually a certified family law specialist?
No, I'm not.
Okay. Have you ever been a certified family law specialist?
I have.
And why are you not currently a specialist, sir?
Because they had asked that I retest, and having taken that test once before, I declined to do so, and also because they have accepted a lot of people as board certified specialists that I'm not sure I want to be a part of that group.
Okay. And you indicated that you're currently working at a firm called Jones and Lobello.
That's correct.
And you previously worked at, was it Black and Lobello?
That is correct.
Is that a separate, distinct firm, or is that just kind of an offshoot of the same firm?
They're a separate firm. Basically, our family law department was comprised of Michelle Lobello and myself, and our associates who did family law and estate planning, and we made a decision to dissolve the Black and Lobello entity So while you'll still see Black & Labello on the building at 215 in Town Center, Black & Labello is simply collecting accounts receivable at this point.
And I believe you indicated that you have represented Ms. Rasmussen since give or take 2012 to 2013. Is that right?
Yeah, now that I saw that the action was filed in 2012, I was not her first counsel, so I think I probably started representing her in the early part of 2013.
And you indicated that I think you indicated previously that you represented her in a pro bono capacity.
I have. I think it's the longest running pro bono case in the 8th Judicial District Court.
And given the fact that you represent her in a pro bono capacity, is it fair to say that you have a vested interest in this case?
No more so than any other case.
But you represent the interests of Ms. Rasmussen, correct?
I do.
Okay.
I'm sorry, did you mean this case, meaning the criminal case?
I'm referring to the family law case. Sir.
Oh, the family law
Yes.
case.
Family law case.
I like to think, I mean,
Okay.
I know for a fact I have a vested interest in every one of my cases in family court.
Okay. But the fact that you've represented Ms. Rasmussen going back many years on a pro bono basis, fair to say your rooting interest is Ms. Rasmussen's interest, correct?
I think I'm required under the rules of professional conduct to have a rooting interest for my clients.
You talked previously about a guardian ad litem being appointed in the case, correct?
Correct.
And it's not uncommon to have a guardian ad litem appointed, correct?
I can, it is very uncommon, frankly. I think in my 23 years of practicing in this state, I've had a gal in cases maybe 5 times, and I handle probably 60 matters a year.
But isn't it correct that in many situations it's even mandated by statute that a guardian ad litem be appointed to represent the child's interest, correct?
Not in a typical custody case. That's always within the discretion of the court. I believe there's a requirement of a gal being appointed in certain types of cases, but it's not a requirement in a child custody matter.
What about matters where paternity is at issue? Is it required then?
I believe so, yes.
Okay. And that was this kind of case, correct?
Not at, well, I mean, I think it originally started off as a C designation case. So it was a custody case to establish parental rights and make orders for custody of the child.
But this particular case was eventually sealed as to paternity, correct?
I believe so.
And do you recall the date that was done?
No, I'm sorry.
And you said during direct that you were actually looking forward to putting this trial on, correct?
The trial back in 2013?
Yes.
Yes.
And you said that my client was represented by Louis Schneider at the time.
That is correct.
And there was a stipulation of appear between the parties.
There was stipulation placed on the record in open court on the day of trial.
Who actually put those stipulations on the record, if you recall?
I read them into the record, and then generally how we do it in family court, if we have a stipulation, is one side will read all the terms into the record. Hopefully they'll be complete terms. If they've made a mistake or missed a term, the other lawyer will chime in. Then the 2 lawyers confirm that, yes, that represents all of the terms. And then the court confirms that to be accurate with the parties, and then it's considered to be an entered stipulation.
In this particular case, how long did Ms. Hammer, if you recall, have to consider the stipulation before it was entered on the record?
Well, I looked at the transcript of the hearing, and I believe we made a representation that it had been 2 to 3 hours that we were there at the courthouse negotiating the case. And obviously, the opportunity to settle existed long before the day of trial, every day between the day of the filing and the day of trial.
And kind of going through a little bit through the timeline that the state put on the record. So 2013 is when the orders were entered, correct?
That's
And
correct.
I believe it was 4 years later that was the first time the court was asked, the family court was asked to intervene again, correct?
I don't remember exactly how long it took. I want to say I remember there being hearings regularly because of issues that had arisen, but I without the entire docket of the case, I wouldn't be able to tell you the timeline at which time there was no activity versus a flurry of activity.
Well, I think you testified on direct that the first time the custody timeshare was modified would have been September 2017 when there was an issue over changing schools. That was the first.
That was when the timeshare was modified, correct, but there had been other issues.
But previously, before 2018, there was no pickup order issues, correct?
Correct.
Okay. And turning to the July 2018 pickup order that the state referenced, I believe you previously said that the child in question had potentially been missing for 33 days, correct?
Correct.
Prior to asking for that pickup order, were any affirmative steps taken on your part or Ms. Rasmussen's part prior to that?
Yes, she tried to exercise her custodial time and was unable to obtain the child. The problem is the way the schedule was specifically designed that during the school year, exchanges took place at school. My client would pick up from school on Monday and keep until drop-off school Friday. So because we were in the summer at the time, school was out, it was all about finding the child when she would go to Ms. Hammer's house to pick up the child, and the child was, and she was refused.
To your knowledge, was there, prior to the July 31st, 2018 pickup order, was there any communications, either by you or by Ms. Rasmussen, making inquiries about the situation?
You meaning other than showing up at Ms. Hammer's house to pick up the child and being told no? I believe the police were called by my client because of the failure to produce the child at the scheduled time. Generally, communications with Ms. Hammer were not productive. So I don't know that I ever reached out to her informally.
Okay. Or formally, for that matter?
I mean, other than filing the motion?
Yes, other than filing the motion, sir.
I don't know of any other formal way to reach out to her other than seeking court relief.
Well, as an experienced family court practitioner, it's not uncommon to send a letter, correct?
Right. As I said, communications with Ms. Hammer in that nature for several years had proven to be completely fruitless.
And you don't specifically recall whether or not you sent out a letter, an email, or any documentation prior to serving the pickup order?
I do not know if I did or not.
Okay. And at the pickup order hearing on July 31st, 2018, fair to say it was somewhat contentious, correct?
Yeah, well, yes, it was contentious.
And voices were elevated on both sides, correct?
Some people accuse me of having an elevated voice simply because my voice tends to carry, even when I'm talking in a conversational tone. But I do recall raising my voice a few times in response to Ms. Hammer raising her voice in order to make sure that the court understood what I was trying to convey.
Well, at that time, there were actually some issues on appeal before the Nevada Supreme Court, correct?
I believe there were still 2 issues remaining on appeal of I believe there have been 7 or 8 appeals filed by Ms. Hammer at various times over the course of the custody litigation, and 2, I believe, were still left.
And because of that, at the time, the court was somewhat reluctant to intervene given the appellate matters, correct?
The court was, Judge Harder takes very seriously any concerns he has with regard to a divesting of a district court jurisdiction in the face of an appeal. So What he basically said is he wasn't going to address any new matters that might be subject to the appeal, but that he obviously could enforce the existing court orders.
And Ms. Hammer did note that there were issues on appeal, correct, at that hearing?
I think the judge noted them first, but yes, they were noted by both the judge and by Ms. Hammer.
And when Ms. Hammer noted it, you became frustrated and you accused her of filing serial motions, correct?
Yes, well, I didn't accuse her of filing serial motions. I made a statement that she's filed serial motions. And if anybody were to take a look at the docket in the custody case, there's not a single person with an IQ over 50 who wouldn't agree with that.
So fair to say, based upon that statement you just made, is you have a dislike of Ms. Hammer, don't you?
No, I don't dislike any litigant. I believe that her actions throughout this case have been contrary to the best interests of the child. And I very much would love to not be on a pro bono case for 9 years. I would very much love for the case to actually end.
You just questioned her IQ right here in court, didn't you, just now?
I didn't just question her IQ. I said anybody who would look at the docket would come to the same conclusion that she had filed serial motions.
Well, isn't it true that in the middle of the hearing, you said, quote, the problem is she has no understanding about what the hearing, this evidentiary hearing is. The evidentiary hearing is our motion to change custody from joint to primary. You said those words, correct?
I said those exact words because she was acting as if there were issues before the court set for evidentiary hearing other than the motion to change custody, because when you file a motion regarding custody matters, the court, if it believes it has merit, will set it for an evidentiary hearing. It cannot make permanent revisions to a custody order without a trial, without an evidentiary hearing. So that was how the evidentiary hearing was set. Plus, there had been a remand order from the Supreme Court for the district court to conclude whether or not 3 people can be on a Nevada state birth certificate. And if there couldn't be 3, their directive was that the court was to determine which 2 of the 3 people involved should be on the birth certificate. So there had been a remand that was set for evidentiary hearing on that issue. Those were the 2 issues that were set for trial, and the statement I made was because Ms. Hammer was making statements as if there were other issues before the court for the upcoming evidentiary hearing other than that which was true.
And in your role as a judicial officer, isn't it correct? It's the courts, the judge, he decides what issues are properly before the court, not you, correct?
Objection, Your Honor. What I think he's misstating it. The judge determined that based on the Supreme Court's limited remand, there were certain issues he didn't want to go forward with.
Well, and I think I can answer the question that I think he intended to ask.
It's a fair question, Judge.
Well, Judge Harder had already decided.
You don't get to rule on the objection.
Oh, I'm sorry.
I just think we're going a little bit outside the scope. I mean, obviously there were issues on appeal, but I mean, and I can ask on follow-up, but I don't think that the issues on appeal are relevant to...
I don't know if it was a bad question or not, but I can take judicial notice that a judge decides what's going to be heard at a hearing.
Fair enough. And in fact, during the course of the hearing, the judge did discuss the issue of contempt following the pickup order, correct?
Correct.
And you actually chimed in, if she spends some time in jail, maybe she won't violate the court order here.
I made that argument 100%. I think I've made that argument at several hearings in this case.
And later on, you also said that, hey, maybe we should issue a bench warrant as well.
Well, the bench warrant was if she didn't return the child.
You suggested a bench warrant, correct?
Absolutely.
And in fact, towards the end of the hearing, you made a request of the court about what school the child would go to, and the judge essentially said, we'll address that at a later time, correct?
Well, I think I sought to confirm, there's already been an order that the child would go to school in Ms. Rasmussen's zone, wherever Ms. Rasmussen was zoned. So I think I was just seeking to confirm that that was where the child would be going to school, out of fear that we would have the same issue we had had the prior 2 years with Miss Hammer changing the school on the first day of school.
Course indulgence, please. And during the course of the hearing, you basically accused her of violating every order, correct?
I think I made, go ahead.
I was just gonna say objection to the extent that it misstates every order.
Responses. He may have objected to every order.
I don't know that I made an accusation. I think I might have argued to the court that she has violated repeatedly the orders of the court.
With regard to the child going to the right school, isn't it correct that you said, quote, but she's going to violate it? She violates every order, Judge.
It had been an annual thing, so I was making the argument that based upon the 2 prior years at which she changed the school unilaterally in violation of the legal custody order, that it was going to happen again. Unfortunately, the judge told me he's not allowed to predict the future, something along those lines.
And do you recall specifically saying, though, she violates every order, Judge?
I don't recall specifically saying it, but if you're reading a transcript, it wouldn't be shocking if I said that in this case.
We're looking at, have you had a chance to review the transcript of Tuesday, July 31st, 2018?
I watched the video of the hearing.
Okay. We're looking at a transcript of the same. Refresh your recollection in terms of what you said at that point in time.
Sure. Is it certified? If it's a certified transcript,
Am I allowed to approach, Your Honor? Or I just want to make sure.
You can.
Okay.
I think he already agreed that if you're reading it, that he didn't dispute that he said it.
Okay. Page 27, lines 20 and 21.
Okay.
I'm specifically referring to lines 20 and 21 on page 27 to look at as little or as much as you need.
but she's going to violate it. She violates every order, Judge. That sounds like something I would say in this case.
So that's what you said then, correct?
I believe so.
And Ms. Hammer ultimately complied with the July pickup order, correct?
He delivered the child to family court as instructed by the court.
Which is compliance, correct?
I believe so, yes.
You were asked on direct by the state about whether Ms. Hammer made any allegations of abuse. Do you recall that question?
At the July 31 hearing?
Yes, sir.
2018? Yes, I recall being asked that question.
Isn't it also correct that the court did not make any further inquiries into that line of questioning? Or I'll strike. Isn't it correct that the court did not make any inquiries into that line of questioning?
The issue of abuse of the child was not raised at all, so there wouldn't have been a reason for the court to make any inquiries.
And the July pickup order specifically referenced Ms. Hammer's address in, I believe, in California and also in Henderson, Nevada. Is that correct?
Yeah, I believe it included her mom's address in California and her address in Henderson.
And the pickup order from October 2018, that was some months after the July pickup order, correct?
Yes.
court's indulgence. Specifically referencing now the Nye County order, which I believe State's Exhibit 2, if I'm keeping track, correct?
Yes.
Okay. With the Nye County order, that was a separate and distinct matter from the pickup orders from July and October, correct?
I believe so, yes.
And suffice it to say, you did not have any direct involvement with Judge Lane or his clerk writing that court order from Nye County, correct?
No, I did not.
Unlike some other orders in the case, this order was not drafted by you or written by you, correct?
Correct.
And you said you got wind of the Nye County order on direct. How did you, quote, get wind of that or knowledge of it?
Well, no, what I learned upon reviewing it is that the judge served me with it, so that's how I got wind of it.
And going back to the October 2018 pickup order, which you were asked about, I believe you said on direct that you assumed she was aware of it, correct?
Well, I mean, I served her at her place of residence on an adult person living in the home.
Okay. Push brief indulgence may confer my client this very briefly. And your client, Ms. Rasmussen, was not a party to the Nye County proceedings, correct?
No, she was not.
Subject to a potential stipulation between the parties, I don't have any further questions for this witness this time.
Any more from the state?
Just a brief follow-up. Regarding the questioning, regarding issues that were up on appeal, when certain issues of a case are on appeal, does that negate all of the orders that have ever been issued in a case?
No. The orders continue to be in full force and effect unless the court stayed in order, unless the district court stayed the order or the Supreme Court, in the absence of a district court stay, stayed the order. And also collateral matters under cases like Honeycutt and McManley, collateral matters that are not associated with the issue on appeal can also still be adjudicated.
Right, so in this particular case, even though there were various issues on appeal, the custodial orders that were in place regarding custodial timeshare and enforcement, Judge Harder had authority to rule on those.
Absolutely.
And that's why the pickup order was granted.
Correct.
And for the record, the issues that were on appeal at the time did not challenge the ultimate custodial orders or the parentage determination of Miss Murphy Rasmussen.
That's correct.
Objection calls for a legal conclusion.
Your Honor, he opened the door by raising the fact that there was all these issues on appeal, and I think we're
Allow it. You just asked whether it challenged it.
nothing further, Your Honor.
Now, here's the stipulation. I believe we have a stipulation on this. Otherwise, I may have to ask a couple foundation questions of this witness. So, as Your Honor knows, I came into the court halfway in. So, I don't know if either in the state's original motion or in prior counsel's objections to the same if the court ever received or had an opportunity to review a copy of the video of July 31st, 2018, because I believe at trial that's what the state would try to introduce. So I will represent, and we can also look at my laptop if you like, that this is a true and correct copy of the July 31st, 2018 pickup order video, and I believe it's important for the court to be able to review the same to determine whether or not it is actually admissible at trial based upon the Tinge state test.
You want to offer that as a?
I would offer this as defense exhibit A, either stipulate it, or if I need to pull my laptop out and lay some foundation on it.
I don't need that. I won't object to the video. I just don't know if that's what's on there, but I mean,
I'm happy to pull my laptop up and show it right now.
take counsel's representations. He's an officer of the court that is an accurate copy of the video. So if,
Stipulate to admission.
yes,
Okay.
that's fine.
Permission to approach for marking?
Okay, defense exhibit A will be admitted. You're saying you want me to watch that before I enter a ruling, probably?
I think it's crucial for the court to be able to fully review the same, because in terms of the test and the factors the court has to review, it's essential, yes.
Is it the state's intention, I guess, to offer that video as evidence at the time of trial to establish this?
Right. I didn't think it was necessary for the burden that I have for this particular hearing, but if the court would allow this this particular act to be admissible at trial, then I would probably show the video as a more thorough representation of what
I
happened.
probably should look at it then. That's fine. What else?
No further questions for this witness.
Okay, thank you, sir. You can step down.
I'm subject to a subpoena. Am I released?
You're released.
Thank you very much.
Thank you, Mr. Jones.
Witness is Mary Rasmussen.
You want to grab her?
Thanks, John. Yeah, I got it.
Look, that one went a little bit longer than I thought it was going to. I've got a lunch appointment at 12:30. So if we don't get through with Ms. Rasmussen, I mean, we could take a break for an hour and come back. I'm okay going later this afternoon, but
I mean, I don't know I don't think our questioning is very lengthy for.
Yeah, I should be pretty short with her. I say that, and then, we'll be.
And depending on where they go,
Famous last words.
I don't anticipate a whole lot of questions either, depending on what direction they take.
It's a limited issue, so I'm trying to at least.
come on up, man. We're going to have you step all the way up on the witness stand if you would. Once you get there, if you please remain standing and raise your right hand and be sworn.
You solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you, spelling the name for the record.
Mary Rasmussen, Mary Johanna Rasmussen, aka Murphy, MaryJohanna Rasmussen,
We can go ahead and be seated. I like the mask because it has the 3 X's. That's like Department 30.
I didn't even realize that.
My kid gave it to me, she loves me. It's just.
May I begin, Your Honor? Ms. Rasmussen, how old are you?
46. Oh, I'm sorry, 56. 56.
And do you have any children?
Yes.
Who's that?
London,
And how old is London?
14, going to be 15.
When's her birthday? And are you listed on her birth certificate?
Yes, I am.
Are you her biological mom?
No.
Who is her biological mom?
Julie Lachelle Hammer.
And do you see Miss Hammer in the courtroom today?
I do.
Could you point to her and identify a piece of clothing she's wearing?
She's on the end, there's counsel, and then she's on the end, very large mask with black and white striped sweater.
Your Honor, would the record reflect identification of the defendant?
Will so reflect.
And were you and the defendant in a domestic partnership relationship?
We were in a relationship, but not like the legal domestic partnership.
Were you in a romantic
Yes.
relationship?
Yes, ma'am.
And when did that relationship begin?
July of 2000.
And when did you and the defendant separate?
Came home to a moving truck that I got in the morning. August 17th or 18th of 2011.
Were you and the defendant together when London was born?
Yes.
And how old was London when you guys separated?
5.5.
And after that, you and the defendant separated, did you petition for custody of London?
Yes.
When was that?
September, I started the process in August of 2012, but officially September 2012.
And was that in the family division here at the 8th Judicial District Court?
Yes.
Who was your attorney in that case?
John Cerizio, who is no longer with us.
And then did you ultimately get another attorney?
Yes, he helped me when we won the brief, and we won the I was seen as the father regardless of gender, 50-50. I got that on December 20th of 2012, and then we were scheduled for an evidentiary hearing in January. We had a court hearing in January, and then he withdrew because he wanted some more money. And so I got new counsel.
And who was your new counsel at that time?
For a minute, it was somebody Rosenblum from Half Price Attorneys. She took the case and then was overwhelmed by pleadings. And so ultimately, John Jones reached out to me.
And when did John Jones become your attorney?
Late February of 2013.
Did you and the defendant ultimately reach an agreement as to custody in 2013?
Yes.
And between 2013 and today, were there times when the defendant would disregard the court orders and keep London from you?
Absolutely.
Specifically directing your attention to summer of 2018, was there a time when London wasn't returned to you pursuant to a court order?
Yes.
When was that?
It was, so she got picked up sometime late June, was supposed to be gone 2 weeks, and ultimately I wasn't returned in 2 weeks, and we had to start court proceedings.
So late June was when she essentially was
33
missing.
days.
And who was keeping London from you?
Julie Hammer.
And how did you know that the defendant, or Julie Hammer, was keeping London from you?
First of all, I went to the resident multiple times during that time, and each time that through my text messages, I'm like, I'm here to pick up London. If there was no response, I would call and have the Henderson Police Department come out and try their best, and then also create an event number.
Okay, so you said you went to the residence. Is that the defendant's residence?
The defendant, yes.
Ms. Hammer's residence?
Yes.
Okay, so you went there to pick up London?
Yes.
And then, just so I can clarify, then when you got there, you called the police?
I would get there and I would try and do a polite text message first, and then I would wait. And to no avail, I would call just to keep a clear record of all the times I was not getting my daughter.
Okay, and were there any other actions that you took to get the defendant to comply with those court orders?
Reached out legally through my attorney.
And so in July 2018, through your counsel, did you request the court to issue a pickup order?
Absolutely.
And was a pickup order ultimately granted?
Yes.
Now, I think you had previously said that, but at the time of July 31st, 2018, how many days had London been missing?
Repeat the question, please.
How many days since July 31st, 2018 had it been since you saw London?
33, mid-June to the court demanding her to bring her to court on July 31st.
And when did you see London after the first pickup order was granted?
I saw her at the courthouse.
And that had been the first time?
Yes.
Following London's return in 2018, did the defendant conceal or keep London from you again?
Yes.
When was that?
October 18th, 2018, or 19. It was a Friday. So it's the 18th or the 19th in 2018.
How long was she missing that time?
49 days.
Where did you ultimately find London?
Knoxville, Tennessee.
And did you give permission for the defendant to take London in July of 2018?
Repeat that?
Did you give the defendant permission to take London in July of 2018?
Absolutely not.
Did you give her permission to take London in October of 2018?
No.
I have no further questions for this witness.
Trustee Zane? That was a lot faster than the last one.
I tried.
You testified in direct that you had a domestic relationship with Ms. Hammer, correct?
Yes.
Was that actually a registered domestic partnership?
No.
Okay. Are you currently married today?
Legally, yes.
Okay. Were you married at the time of this relationship with Ms. Hammer?
Objection, relevant.
It's relevant because those are some of the establishment questions that they asked at the beginning. I think I'm entitled to clarify.
If they were in a romantic relationship, what does it matter if she was married or not?
Is that concern, Judge?
I'll allow it. It's foundational, I think.
All right, let's just get real here. I had a friend of mine that I got married to in 1988, March 4th or 5th. I had surgery. Person saved my life. Got on a plane. I've never seen him again. Julie Hammer is completely aware of who this person is. You know, you have pillow talk. You talk about and who you've been with. Never in a million years had I completely actually forgot. So at least I was honest about that. There's been no communication. I've reached out, tried to find. I could do a divorce. I could be divorced. I have no idea. When the time comes, if we were to get married, we would have done the right thing where you put in an ad in the paper, blah, blah, blah. That's it. And as far as Julie and I being in a relationship, would you like some pictures or videos?
Nope.
Okay.
And you were asked about the series of attorneys that you had, and eventually John Jones took the case, correct?
I've had 3. John Cerizio, Molly Rosenblum, and then John Jones.
And with specifically as to John Jones, was there a retainer in place or was that pro bono?
There was a retainer.
Okay. And you were asked some questions about steps that were taken in July 2018. At any point prior to the July pickup order, did you ask for Mr. Jones' assistance in your issue with Ms. Hammer?
I'm sorry, can you ask that a different way?
You testified on direct that you utilized Mr. Jones' services for a July 2018 pickup order, correct?
Yeah, Mr. Jones has been involved in every order since 2013.
But around the time frame of 2018, I believe you testified on direct that you went to her residence multiple times, text messages. Did you ever utilize Mr. Jones to communicate with Ms. Hammer, other than in court?
I'm sure I utilized the police department and I utilized my attorney.
And turning to the July 31st pickup order, Ms. Hammer complied with that order, correct?
There was a lot weighing on her if she didn't bring the child to the courthouse.
So she complied, correct?
Yes.
First indulgence. No further questions?
Motion to state.
Just briefly, I just want to clarify Mr. Jones's representation. He was originally retained and then later worked to be pro bono, correct?
Yes, because of all the filings and the other party not complying, it lasted longer and longer and longer than it ever had to.
I have no further questions, right?
And can I
sorry,
just,
do you want to finish?
Yeah, I just want to, this also happened in the summer of 2017. Ultimately, we were 2-5, and then in the result of her not wanting to bring her to school in the summer of 2017,
I'm going to move the strike as non-responsive at this point to the question.
my timeshare, I just want to say, was from Sunday at 3 p.m. until Friday after school.
It was non-responsive. It'll be stricken.
Thank you.
I understand, Your Honor. I have no further questions.
No further questions.
Thank you, ma'am. You can step down.
Enjoy that.
Any more witnesses for state?
No further witnesses, Your Honor.
Have any witnesses?
Brief indulgence.
think you should be.
Your Honor, can the witness stay if there's not going to be any further witnesses?
I'll just say this for the record. I've advised Ms. Hammer of the right to testify in this proceeding and every other proceeding for that matter, and she is electing not to testify at this time on the advice of counsel.
That's
And
fine.
with that, we have no witnesses.
Fine. You have a problem with Mr. Rasmussen staying in here then?
As long is your mic? I believe Ms. Hammer also has family support as long as she's allowed in as well. That's good for one party, it's good for the other.
You want to make an argument?
I mean, I have an argument if the court would find it helpful just regarding what this, well, yes, I'd like to make just a brief argument. Okay, thank you. So as this court's aware, the state's burden under Big Pond is whether or not the prior act is relevant. It is relevant for something other than the defendant's propensity, and that it's proven by clear and convincing evidence. And then ultimately, if its probative value is not substantially outweighed by the risk of unfair prejudice. The state is seeking the admission of both the July 2018 pickup order and the August 2018 Nye County order for several purposes. One, to prove the defendant's intent and motive to commit the underlying crime. Secondly, to prove the defendant's actions were not done by mistake, but that she had clear knowledge of the law and the orders when she committed the abduction in October of 2018. And to show the defendant's plan in committing the underlying crimes when the family court judges failed to rule in her favor in July and August of 2018. It is clear from the evidence that the defendant had an overarching plan to kidnap the child, which was executed on both occasions. Her acts were not spontaneous, and it was an organized plan. The state has proven the clear and convincing evidence standard for several bases. Specifically with the July 2018 pickup order, the defendant violated the court orders when the Clark County judge issued the orders. The defendant essentially admitted to concealing the child for 33 days at the time of the hearing when she failed to rebut the arguments made at the hearing. The defendant failed to provide the court with a specific location for the child and instead was ordered to return the child at family court. The July 2018 pickup order is a certified court order. With respect to the Nye County order, the defendant was intentionally playing games by attempting to circumvent the jurisdiction of Clark County when she attempted to amend the birth certificate by filing in Clark County. And that is evident, and I will use the word scathing, order issued by Judge Lane, which we heard on the record. Additionally, the Nye County order is a certified court order. The totality of the circumstances for both acts show that by clear and convincing proof, the defendant intentionally kidnapped the minor child in 2018. There is no risk of unfair prejudice to the defendant. And this Supreme Court issued a decision in December of 2020, Randolph v. State, 136 Nevada Advanced Opinion 78, which outlines 6 factors the court should consider when balancing the probative value against the danger of unfair prejudice. The first being the strength of the evidence as to the commission of the other act. Both pieces of evidence in this case that the state is seeking to admit are certified court orders, which alone proves the defendant's actions in this case. Additionally, the defendant admitted to concealing the child, and the defendant knowingly filed pleadings in Nye County immediately following the issuing of the pickup order in July. The evidence against her is overwhelming. The second factor is the similarities between the crimes. Well, the crimes in July 2018 and the crimes in this case are identical. They are both violations of the custody order in the Clark County domestic case. The act was a result of orders from the same domestic proceedings against the same parties and regarding the same victim child. As to the Nye County order, the defendant filed court pleadings regarding the same child as the Clark County matter with knowledge that Nye County didn't have the jurisdiction. The third factor the court's to consider is the interval of time that's elapsed between the crimes. The crimes that the state, or the acts that the state are admitting, are just 2.5 months prior to the underlying crime, so there is not a large interval. The fourth factor is the need for the evidence. The evidence in this case is necessary to prove the defendant's intent, absence of mistake, and plan. Additionally, it's anticipated that the defendant is going to assert an affirmative defense in this case of necessity, which is allowed under one of the statutes. So this evidence will be necessary for the state to refute that defense, and specifically that the defendant did not raise allegations of abuse prior to July 2018 when the court issued the pickup order. Therefore, she now claims that there's a history of abuse as a way to defend her actions in 2018. Her statements and actions in July 2018 are necessary. The fifth element you're to consider is alternative proof, and ultimately the state's position is the analysis I just made regarding the need for evidence is the same. And the last factor that the court's to consider is the degree to which the evidence probably will rouse the jury to overmastering hostility. That's the language the court made. And here, the underlying crimes that the state is trying to get in here are the same crimes. They're not it's not like a juror is going to come and say, well, she committed this heinous crime, and so then she's committed this crime. They're the same crime, so there's really no risk to prejudice there. The state believes it's met its burden under Big Pond and the Randolph factors, and so I'd ask the court to make the following rulings: that with the July 2000 pickup order, that the state satisfied its burden and that the evidence is admissible to prove intent, absence of mistake, motive, and common plan or scheme. And with respect to the October 2018 order, that the state has satisfied its burden under Big Pond and that the evidence is admissible to prove the intent, motive, absence of mistake, and common plan or scheme. Thank you.
You talked about July and October. I thought it was July and August.
Sorry, July and August. I apologize. The July and then the August Nye County order.
Okay, so I guess I'm a little bit confused. The August order, I thought there was two pickup orders from Clark County.
There is, but the October 2018 pickup order is the underlying crime here. The detention and concealment charge in this case is the October pickup order. So that's a necessary order for the underlying crime. So I'm trying to get in the July 2018 pickup order and the August Nye County order issued by Judge Lane.
Okay. Got it. Thank you. Vince?
Thank you very much, Your Honor. And this court is well aware of the standard under Big Pond, as well as a presumption of inadmissibility as to prior bad acts as set forth in Tavares v. State. So I want to start out by talking about some of the distinctions between those two pickup orders. So I think the testimony itself made clear today that the July 31st, 2018 pickup order was sometime approximately 2.5 to 3 months before the October pickup order. Those are two distinct and different acts, which I would submit are separate in time. It's clear that Ms. Hammer was never subject to any criminal charges based upon July 18, 2018 pickup order, the July 2018 pickup order. And further, the testimony presented makes clear that she complied with the July 2018 pickup order. And what we have here with the new pickup order is simply allegations. So I would say relevance to the crime charge, they have an issue there. And again, just to make it clear, the indictment, she's only facing allegations from October 19, 2018 through December 18. That's the range, Judge. It's not about the earlier event whatsoever. So I would say that, it's not relevant to the crime charge, and it's simply for proving propensity. As far as clear and convincing evidence, I believe the state said just now, well, she had a chance to rebut it, but that's why I really want the court to take a very careful look at the video of that hearing. And I would proffer that if you view that video, you will see from our perspective that you basically have a combination of a judge and opposing counsel basically berating our client and basically kind of yelling, almost basically scolding her into silence under penalty of potential sanctions. So she was not able to rebut anything as the state asserts. So I would say we don't have anything proven by clear and convincing evidence. And in terms of the probative value substantially outweighed by the danger of unfair prejudice, it absolutely is outweighed by the danger of unfair prejudice. I mean, what did Tavares say? The principal concern with committing such acts is the jury will be unduly influenced by the evidence and thus convict the accused because it believes the accused is a bad person. And it would be one thing if the state was simply trying to omit the pickup order itself. But I think the state made it clear today that they want the actual video in. That's why I want the court to look at for purposes of this hearing only. And the concern that the defense has is if a jury sees that video, that they will basically say, well, if a family law attorney said this, and if a judge said this, then you must have done something, folks. And therefore, she does not get a fair shake in this court. So all we're asking is a fair shake. So I would say they meet the test whatsoever to even have it relevant, given the separate and distinct actions. But if the court, against defense's wishes, believes that anything should come in, at most, it should be the pickup order and not the video or not the transcript behind it, because it's obviously prejudicial. And I think the video, how do they say in Latin, res ipsa loquitur, it speaks for itself. And I would say it speaks for itself, Your Honor.
I don't know that the orders would have any foundation without some type of background coming in, would they?
Well, obviously, the state knows how, just like the defense does, the state knows how to lay foundation as well. As far as the Nye County order, I think the testimony made it clear that it is, and I think Mr. Jones himself admitted, that it was a separate and distinct action from the orders. The state says, well, the defense may do the defense of necessity, and they kind of expand on that a little bit about what the defense allegedly is going to do. But the case law is also clear. You know, you can't assume what the defense is going to do in their case in chief. And I think it's highly speculative at this point for them to say, well, we want to get this in under the guise of what an alleged defense theory might be. And I think the prejudice prong is clear as well. They're seeking to omit this evidence to essentially, you know, put a stain on Ms. Hammer to say, well, if she was chastised by this court, go ahead and chastise her here as well, folks, because she's allegedly engaged in wrongdoing. Bottom line is they don't meet the prongs, and they particularly don't meet any of the prongs of the probative value not being substantially outweighed by the danger of unfair prejudice. Of course, brief indulgence. Okay. I'll submit.
Last words from the state?
Yeah, Judge, just to clarify, I don't have to bring in the video, so if the court watches it and feels like that for some reason is overly prejudicial, but I think it provides some context, and I think that's important, especially when the underlying crimes in these cases are a violation of a court order. And for a jury, they need to have at least a little bit of context as to what the background and the history is in order for the state to be able to show that she violated the order in 2018, which is why she's charged with a crime. And obviously, this is a prior uncharged act, so it's going to be prior to the crimes that are alleged in this instant case. That's what we're trying to get it in for those other reasons of intent, motive, and plan. Because what we have here is someone concealed a child for 33 days. The court ordered her to return the child that day at family court. Yes, she did comply, but then the next day she goes to a completely different jurisdiction and tries to circumvent the court here in Clark County in family court and file proceedings there. When all of those things failed, what does she do? She conceals the child again, but this time removes her from the state, and there's going to be several other evidence that we'll present at the time of trial, but this is an overarching plan. When she didn't get her way, she went the next step. And that's important for the state. And while I realize I don't know what their defense is going to be, I do have to be anticipating that and bringing evidence that's lawfully before the court. So if at the time they raise that, then I can properly present this evidence. And if I didn't, then they'd be standing up and objecting, saying they didn't get their Petrocelli hearing. So the state is doing it out of its burden to present this evidence prior to trial so that the court can make the proper ruling. Thank you.
Thank you. Since I have to watch the video before I make a decision, I guess I'll take it under advisement. I'll get you a decision as quick as I can.
Thank you, Your Honor.
Thank you.
Thank you,
Appreciate your
Honor.
time. Have a good day.
I said, one question on the record, if the court's able to indicate it. Right now, we currently have a July trial setting. Is the court able or willing to give any indication on where we're at in the stack so both sides can either plan or?
Where you're at in the stack doesn't really matter. What matters is if the county commissioners allow us to, they're supposed to come out with a plan today telling us whether or not, what their position is going to be on the social distancing since the governor lifted the statewide mandate.
Okay.
I think that decision may affect what the court does as far as opening the courts or not. And I mean, as you know, right now we still have, I think, 2 courtrooms on the 3rd floor that we're doing. It's still just invoked and in custody people. So I don't know how fast we're going to be able to get through the backlog. If we're done with invoked in custody people and we can do the trial, we'll do it.
Understood.
I don't know. That's the best answer I can give you. Sorry.
Understood.
Yes, Your Honor. Thank you very much.
Take care.
Thank you.
Take care.
I can tell you it is kind of a pleasure having people actually in the courtroom again.
Thank you very much, Your Honor.